So, Council, you're welcome.
Thank you, my brother.
And it's good to see you.
It's a pleasure also seeing you.
Right. So, this afternoon, we're going to talk about judgment debt and the steps you took to get Parliament to amend the contract law, which the President has sent it to you. We're going to find out what really is contained in this and what public officers ought to know. But, I mean, in court today, the Supreme Court, in a unanimous decision, dismissed what Roxanne Dafiamebo was seeking to have the court do and to continue to hold Parliament not to approve the President ministers. Your initial reaction to what happened in court today?
Thank you very much. The Supreme Court has spoken. As the AG said, the application has been dismissed. So, legally speaking, there's nothing holding Parliament from going ahead to do the approval or otherwise of the ministers vetted. Mm-hmm. And I think in respect of how things unfolded, I agree with my boss. If you file an application and you fail to go to court, the court has various options. One of them is to make sure that is to ensure that the application is heard. Mm-hmm. So today, the applicant was not in court, and the Supreme Court, in its wisdom and in accordance with law and rules of procedure, heard the application and dismissed it.
Is it strange or normal that applicants to a case will fail to show up? I mean, when it matters most?
It is not very abnormal. It's possible that you may file an application, and when the time comes for you to go to court, you may not go to court intentionally, or unintentionally, you may not go to court. But whether you go or you do not go, it depends on the explanation that you offer. So if an applicant to an application and you don't go to court, the court can deal with the matter. Okay. For example, if an applicant is indisposed and he's served an application or hearing notice to come to court, he may, through his lawyer, inform the court, because of A, B, C, D, I'm unable to. But if you are served and there's proof of service, and you decide not to attend court,
right, the
court will not wait for you. The court will proceed and hear the matter.
And that's what happened today.
That's what happened.
So if you are in the shoes of the majority leadership in Parliament, or you are in the shoes of government, what would be your advice? I know that some provisions in the standing orders of Parliament makes provision for instances where the House is on recess, but there's an urgent matter. Once they get at least 1/3 of members of Parliament to sign a petition, that will compel the Speaker to recall Parliament and then hear the urgent matter. If we were in the shoes of government, would you advise the majority to take up this course and get Parliament back to approve the ministers?
All right, Parliament, they have their own rules of procedure and how they do their things. As you said, there's a procedure where some members may want to sign on so that the Speaker of Parliament will recall Parliament. That's another way of doing it. I think this within the powers of the majority to explore such an option, or it can be bipartisan, where both the majority and minority may want to put their heads together and say, in view of what has happened, it would be for us to come again and then look at the approval processes. I think that's the way that I would advise
that it should go. Yeah. All right, so if you are watching us here on Joy News, you can leave your comments on our social media handles, on our Facebook page, on X, and of course, we are live on YouTube. What do you make of the court decision to dismiss the case brought before it by the Member of Parliament for South Dai, Roxanne Dafiamebo? He was seeking the Supreme Court to continue to allow Parliament not to approve of the President ministers until the determination of the matter. The court says it was an abuse of the court process and frivolous. Those were the words used by the 5-member panel that sat on this matter. Well, this afternoon we'll stay in the court, but out of the court into the office of the Attorney General. Now, a law to prohibit the payment of compound interest by the state in transactions entered into on her behalf by public officers has been passed by Parliament and, of course, assented to by the President of the Republic. The law, the Contract Amendment Act 2023 at 1114, sponsored by the Attorney General Minister for Justice Godfrey Yeboah-Dameh in 2023, was passed by Parliament in July 2023, but was presented to the President for his assent only on March 5, 2024, who duly assented to it. According to the Attorney General, the law seeks to curb the inimical tendency on part of public officers to enter into contracts with high rates of interest, especially compound interest, which resulted in huge financial loss to the state. This important amendment to the Contract Act was motivated by observations he made in various actions in which he defended the state in huge judgment debt cases. Deputy Attorney General Alfred, I don't know why I keep calling him Godfrey, but Alfred and Godfrey almost the same. Alfred Yeboah joins me to unpack the law. Before you begin, though, here's the situation. So we don't have the graphic. I will bring you a graphic about how much has been spent. But, Council, again, I mean, tell me the motivation behind the decision to seek Parliament to amend the contract law and to bring in these new provisions.
All right. Now, in Ghana, there is an existing law, the Contracts Act, Act 25. And that act actually governs everything about contract, be it private or government. Now, there have been instances where judgments have been delivered against the state, and in working the interests, in view of the contracts that were entered into, the courts have decreed that interest should be awarded on compound basis. And I think the Attorney General one time made it clear. There was one instance where he had to, that was last year, last 2 years, someone had judgment. I don't know, the person said the state was owing that entity 1.2 billion Ghana cedis. That's the NDK case. And his argument was that having had a judgment, he had worked interest on that amount. And there was a challenge about the use of compound interest in working out that judgment debt. I don't know the day when the challenge was mounted, it came out that not more than 14,000 Ghana cedis was owed by the state.
From 1.2
billion Ghana cedis, yes.
Reduced to 14,000 Ghana cedis.
Exactly. Now, you've also heard about the trillion that the president spoke about.
Yes. Over 10 trillion, he
exactly.
said your office had helped to save Ghana from paying.
Exactly. Someone had judgment in somewhere 2011, and the judgment was not, if I'm not mistaken, was no more than 200 million Ghana cedis. And according to him, he was supposed to get interest based on the arrangement that he had with the state at the time. So he worked out the interest, and it came up to 10 trillion Ghana cedis. 10 trillion Ghana cedis, not billion, trillion, almost $950 billion. So there was a challenge as to how he came by that figure. And then when we went through the process, it was then reduced from, they said fine, there was some computational errors from 10 billion to 3 trillion. 10 trillion to 3 trillion Ghana cedis.
Even that is huge.
That's even huge. So the AG and the officers at the AG decided that fine, let's look at a process where we can avoid such judgment debts, which arise basically because we are having to pay a lot of interest on compound basis. You know, when it comes to interest, we have the simple interest and the compound interest.
Perhaps we'll spend time to explain the two and the difference. Therein.
So this bill that we sent to Parliament, which is now law, is because of the antecedents, how we realized that people were getting fantastic judgment debts just because they were working the interest on compound interest basis. That's motivation.
So who does the computation?
Now, when judgment is delivered in court and the court says pay interest X for a period, the judgment creditor, the person who has won, he may want to file the entry of judgment or certificate of judgment. He will work it and then serve it on the judgment debtor.
Right.
So it's the person who has won the case who work it out and serve it on you. If you dispute or if you doubt it, then you also challenge it. So it's always the person who has won, unless the court says the registrar or a referee should come in to work out the interest for you.
Okay.
So every judgment is a judgment creditor who goes in to work the interest.
So we're going to go into the contents of this amended contract law. But let's say a little longer on these trillions that we are talking about. The president of the State of the Nation address said that the Attorney General office had helped to save the country from paying over 10 trillion Ghana cedis. But was there any money paid, even though you may have worked to bring the amount down? In some of the cases that are before you, that compound interest moved the amount from, I'm told that sometimes from 500,000 Ghana cedis and then all the way to the trillions. Was there any money paid in these circumstances?
In terms of the trillions,
yes.
In fact, when we were served with the entry of judgment, there was a challenge. It came to 3 trillion. And there's now a writ seeking to set aside that judgment.
This is the African automobile case?
Yes. So that matter is pending before the courts. And I think I don't want to go into detail, but what I can say is that from 10 trillion, there was a challenge. It came to 3 trillion, and that one is also being challenged. When the other judgment debts that you spoke about, some of them have been paid. For example, there are 2 forms of judgment debts.
Okay.
Legitimate ones and illegitimate ones. If there is a legitimate judgment debt, the only thing you do is to what? make payment in respect of that judgment debt. So some payments, because no government in our history can ever say, there's no going to pay judgment debts. Because you deal with people. People work on your behalf. You have police officers who arrest people. Sometimes they go outside the scope of authority, the state is sued. People use government vehicles, they knock others, and then state is sued. A whole lot of things. So you may have instances where people have judgment against the state. And the state, upon examining the judgment, will get to know that this judgment is something that is just and we must pay. So those that are just definitely are paid.
But do you have so many on your decks as we speak?
Now, if I would say yes, because you have others like road contractors who are also making demand on the government for works that they've executed.
And government hasn't paid them yet.
Definitely.
And they've gone to court.
They've gone to
court. The court has awarded judgment against
judgment debt. So in that case, so far as there's judgment, it's a justified one because the person must have gone through due process. So what do? You just negotiate with the person to see how you can pay that judgment debt. So every government in our history has faced the issue of judgment debts. But it's about whether they are justifiable judgment debts or unjustifiable judgment debts.
The Attorney General, I mean, in that interview early this month, did not also rule out sometimes the complicity of some state actors in some of these judgment debts, because eventually it may benefit them one way or the other. I don't know whether your dealings have come across the situation where you can come to the conclusion and say that this was clearly an irresponsible act on this state actor that has resulted in the state paying this huge amount of money.
All right. I have not seen it, but I know there have been instances that I have not personally seen, but there have been instances. Now, let me take you this way.
Right.
Now, if you look at the judgment debts, they arise out of contracts with sometimes contractors. When these contractors sue the state, for example, if the contractors sue the Attorney General, the risk is served on us.
Right.
And if it's about the road contract, we then write to the roads ministry or the feeder road or highways for them to get us a response to that suit. At times, you send the letters and you don't get a feedback. And you know, in court, there are timelines. The person sues you, you have 8 days to enter appearance. If you do not do it, if you enter appearance, that one you can enter without even instructions. But your defense should be filed within 14 days. Sometimes you write and you don't get the response. If you don't get a response from that entity and there's judgment against the state, then you can say that officer who failed to respond has occasioned that judgment debt. For you may know, you may have a valid defense to that action. But because you do not have that information...
At the time you needed it.
Exactly. Exactly. So that's how sometimes the AG was saying. We may have instances where state officers, they become complicit. I may have instances where people may also... We all live in this country where somewhere 2010, 2011, we spoke about create, loot, and share.
Right.
Where some officers may also just want to collude with others, create some scenarios, go to court, get judgments, and then share the judgment booty.
So this amendment that you've done, what is it seeking to cure?
Now, it's seeking to cure situations where state officials enter into judgments on behalf, enter into contract on behalf of the state or the republic. And in the body or content of this contract, you have clauses relating to the payment of compound interest in default or in breach of the contract.
Is there a difference between, for example, when the court make a pronouncement and say that pay this amount of money at the prevailing interest rate and then compound interest?
Now, two scenarios, simple interest and compound interest. Simple interest is very simple, let me put it that way, straight line basis. So if it's about 10% on 10,000 every year, it means that every year is 1,000 Ghana cedis. If it's for 10 years, you multiply by that one, then you add it. But compound interest, where you have interest on interest.
Interest on interest.
On interest. So if the first year is 1,000 Ghana cedis on 10,000, it will mean that if we're working the second month, you won't work it on 100,000, but you work it on 110,000. So the interest will go, the rate will go up. So that's our compound. So at the end of the day, you may even have 1,000 Ghana cedis. Simple interest for 12 months, 10%. You may end up paying, for example, 2,200 Ghana cedis because it's 1,200 you're going to add. But for instance, where if it's compound interest, you may even pay more. Sometimes 100,000, 15,000, 20,000, depending on the rate. But there is a law. Before I come to this, there's a law in Ghana when it comes to the award of interest, CI 52. In that law, when the court decrees judgment in your favor and you pray for judgment, the rule is that the court will award simple interest unless there is a provision in your contract to the contrary that you have agreed that the court should award compound interest. It is to cure this that we are saying that if you are acting on behalf of the state, our position is that for every contract, it should be simple interest.
And not compound.
Not compound.
Right.
So if you are dealing with us and you think that you are not interested in simple interest, then you better stop. You can go and deal with other countries. Because we know that if care is not taken and rely on compound interest and there are defaults, you get to a point where the 10 trillion, Ghana was our total GDP.
I mean, that's actually...
That's it. But just one case claiming 10 trillion out of compound interest. Now, if you take the Act 114, there are various provisions. The first one is it seeks to amend Section 17 of the Contracts Act. And it's now including certain clauses or certain sections. One of them being who can have the authority or who has the authority to sign contracts on behalf of the Republic. It's detailed in this act.
And who has the authority under this act?
Now, the minister, the sector minister in charge of that sector. For example, if it's about roads and the contracts about roads, it should be the roads minister.
Previously, it wasn't like that?
Previously, the minister could do it.
Right.
Other officers could, but we just want to be very specific.
That the minister has the final authority
he has
to sign such contract on behalf of the state.
Yes. Or the minister may authorize someone to do it. So, for example, my minister may want to sign, but he's not there. So, Deputy AG, sign it on my behalf. Or he may say other officers should sign on his behalf. The third one is other officers permitted by law. For example, chief directors. There are people who work within the space of the state. So they may want to sign contract on behalf of the state. But even in that one too, they cannot on their own go and then sign contracts. They need to do some various consultation before they do it. The second one is about interest. Under this act, you cannot act on behalf of the state and enter into a contract for the payment of compound interest. If you do so, and it comes out, you can be arrested and prosecuted under this law.
Under this law.
Under this law.
Which is now in effect.
It's in effect. And if you are prosecuted and you are convicted, the minimum sentence is 5,000 penalty units.
And that translates into
12 times 5. That's almost 60,000.
And then imprisonment for
then
up to...
the maximum penalty is 10,000, between 5,000 and 10,000. Or imprisonment to minimum of 10 years and maximum 15 years or both.
And this is for those who may not have authority but may endanger the country because of their own, whatever.
It's not about
authority. This can also apply to ministers of state who have authority under this law but may do things that may not inure to the benefit of the state.
Yes, you have the authority to do it, and then you enter into that contract and then allow a clause that gives the other party the right to levy compound interest on the state. That is it. So in every contract that you are going to sign on behalf of the state, if you're a minister, if you're a government official mandated so to do, you must make sure that you go through it and see that there is no clause burdening the state to pay compound interest in case of any default.
The question for a lot of people will be, why leave the signing of such contracts in the hands of a political appointee whose tenure in office is limited?
I think that shouldn't be a concern, that shouldn't be a problem. Because if you leave, you'll be held accountable. So if, for example, as I sit here as a deputy minister, my minister authorizes me to sign a contract on behalf of the state, and there is a clause in it that the state may be compelled or called upon to pay compound interest. If I leave office tomorrow, I can be called upon to answer questions. So the state, in terms of the state being represented by politicians to sign a contract, I don't think that's the problem. That's why, aside the politicians, as I said, the chief directors may also do it, or you may even authorize others to also do it on your behalf. But what we are saying is that you must make sure that you do not sign any contract on behalf of the state that imposes compound interest on the state.
The bottom line, any business that anybody enters Ghana into, compound interest should have no expression in the contract.
Exactly. And there's also a provision, a section in this law that if you enter into any contract which stipulates that the state will have to pay compound interest, that contract should be declared null and void and of no effect. So if you're a businessman, Elton, and you want to, maybe you are supplying something to our ministry, and then in doing so, I decide to say because we were the same, attend the same school, right? And this one, let's make it compound interest. I'll be punished. But you too, you cannot enforce that contract against the state. Because the law is for all of us. You must all know that you must not claim compound interest against the state.
So this clearly is to guide if you are entering the country into a contract. And it's also to guide those who have authority to do such, business on behalf of the state. Now, in the event that somebody overlook the provisions in this new act and then enter into a contract with a foreign company or a local company, and then compound interest is introduced in the provisions, and this matter is put before a judge in the court, the judge cannot rely on the provisions of this act and then rule accordingly. Is that the case?
If the contract was entered into on behalf of the Republic, and there is a provision in that contract that says that the state should pay compound interest, that bit has no effect.
Okay.
And for that matter, that portion of the contract cannot be levied or executed against the state. So the court, if it's brought to the court's attention, will never enforce such an agreement. Because our regime now is that simple interest should be the order of the day. So if you are not interested in simple interest, then
don't go there.
Don't go there.
So this has been passed. I don't know whether you've undertaken education, you've taken those who are in line of responsibility, whether you've taken them through education to understand the new order in town.
Fortunately, this law, as you said, it went to the president in March. It's now been assented. It's now a binding law. It's presumed that everybody knows the law. But this is what we are doing right now. Now that I'm on this set, people are also listening to me. And at any time there's an act or any bill or any act is passed, at our end, we distribute them to the various agencies and the various agencies and the ministries. So maybe the public education is what we started here, but we continue doing it. Everybody should know that this is the regime that we have now. Compound interest is no longer available when it comes to contracts with the state.
To what extent are our judgment debts causing damage to this country?
Judgment debts, I will be honest and tell you, are matters that we all need to look at critically. We have judgment debts to the tune of 10 trillion in just one case.
Bigger and larger than the entire GDP of this country.
Exactly.
The value of this country, if you like.
Exactly. There was another judgment debt also, almost close to $1 billion. That one was also a judgment that we also set that one aside.
And this was between the state and which party?
Yes, I think state. I've forgotten the other party, but it's a case that came on in Kumasi, the China jail or something. I've forgotten the title, where there was judgment against the state. We challenged the judgment. We went on the appeal process. At the end of the day, the judgment was set aside.
Of $1 billion United States.
Almost $1 billion. Yes, almost $1 billion United States dollars. You also know there was also another judgment debt in Kumasi, $50 million. There's illegal mining and all those things.
Right.
That one, you have to go to court to set it aside. So if
you went to court to set it aside, meaning the case is not, there's no finality on these matters.
Fine. If the judgment against us and we go to court to set the judgment aside and you think that the judge has erred, we also have the right to take the next step. But so far as we are concerned, that's what we have done. I know some of them have filed appeals. Nobody can fault them. That's their right so to do. But we will not sit down for anybody to get judgments. And if we think that judgment is not deserving, definitely we will challenge that judgment with all the laws that we know to make sure that our little resource that we have is protected. Ghana is a state that I can say, just like all other states, we don't have limitless resources. We have limited resources. So in the utilization of these limited resources, we are enjoined to ensure that we use it for the benefit of the people, of the state. And so if you have any judgment against us, which may be a valid judgment, ensure that in the calculation of the interest, you do the right thing. Some people may have the impression that, as for the government, if you even work it out, nobody will look at it.
Yeah.
I'm assured my brother, if you file any certificate of judgment, have in mind that we will scrutinize certificate of judgment. If there's nothing undeserving of that certificate of judgment, we'll definitely go after you and go after that certificate and set it aside.
But again, the concern here is the responsibility of the state and its actors to respect contents of contract it enter into with other people. Because the judgment debt wouldn't just arise from the clouds. Obviously, because the state did not respect its part of the deal. That's how come the aggrieved party went to court and got a call to, award him or her judgment.
You are right. But to cure that mischief, now, if you look at the Public Financial Management Act, there is a section provision in that act that says that you cannot award contracts if you do not have a dedicated funding for it. And so, if you're a public officer, a minister of state, or any government official, before you award any contract to anyone, you have to make sure that at the time that you were going through that process, there was a dedicated funding for it. It's one of those things that we are using to just cure that kind of, because as you said, if you do not go by the terms of the contract that you've entered into, that party will also not sit down.
Right.
The person will go after you. So that law is something that we must all respect. And most of the judgment debts that we have, I think some of them 1999, 2000 and something, old judgment debts. But
and interest on it has built on and it's coming to where we are now.
Yes. Interest has built on. And if the interest was even simple interest, that would be something different. Because you see, if you have the judgment against you as a private practitioner, if I represent you and the judgment against you, I can tell you, Ethan, the judgment is 1 million Ghana cedis. Interest is 500,000 Ghana cedis. We are going on appeal. But because I don't want to be paying interest, if I don't do there's a state of execution, and then we even go to the Supreme Court and we come back and we lose, we have to pay all the interest up to that time. If you have the money, you pay into the court registry so that at least we are able to hold on with the interest payment. I think these are some of the things that we should be looking at. If there's judgment against the state and we have that kind of fight, we even want to challenge it as some forum, maybe in a court of appeal or the Supreme Court, and we may want to avoid paying future interest.
Judgment debt.
We may want to do that.
But has there been an occasion where the state negotiated behind the scenes with a party that are taking the state to court to come to some kind of an acceptable figure?
There have been many instances. You see, you can have post-judgment settlement, where there's a judgment against the state, but you realize that the person is entitled to X, Y, Z, but you may want to negotiate with him that you're entitled to X, Y, Z. The state cannot pay. Please, can you agree to pay X, Y minus 1? Just reduce it. Even sometimes we even negotiate for people to even waive part of the deal, of the interest.
Because I understand that in the matter between the state and the African Automobile, when we spoke to one of their lawyers, Lawyer Bochi, and they said that the AG had filed some processes in court, so there's a hold on the execution of the judgment debt. And even for him, I mean, it was becoming increasingly difficult for them to even continue with the calculation because of the huge amount of money involved. So in such circumstances, how do you weave your way around it?
We have to go through the legal process, unless, of course, there is that kind of understanding that we need to settle our differences. Because if you have instances where one party is saying that I'm entitled to 10% per month, compounded. Look at the implications.
Right.
10% per month, so some of them 6.5% per month compounded. There will definitely be a challenge. Because other party may be saying, no, that's not a position so far as we are concerned. But as you said, if parties are ready to settle, why not?
We'll do that.
Or there are instances where you have to sit down with the other party, look at it, and come to an amicable resolution of a matter, and then we end all this kind of litigation in court.
Is this a major challenge at the ministry? The issue of judgment debt.
Judgment debt, as I already told you, is a border to us. And it's not really about contracts. Sometimes it arises out of actions of state actors. And I made a suggestion somewhere that it should be possible. I think it's legally also possible that if you're a state actor and you go outside the scope of your authority, if you're a police officer, you decide to molest people outside the training that you've been given, and the person sues and there's judgment against you, the state must also make sure that that money we're going to pay, we pursue you so that we pay the money back to the state.
But let me just find out, do you get such cases, police brutalities and people seeking redress?
We have them. We have them. Where the police service is sued, the agency is sued, and we have to go to court. Sometimes we try to even settle.
The most is about what abuse on the citizen by a police officer?
Sometimes. Sometimes it's about purely, you look at a situation where someone, not a police officer, I don't want to just bring them to the picture. A state officer may be driving a vehicle then he knocks down someone on the road. Then the person sues, we have to pay. So there this kind of judgment that we have small and bigger, small. But at the end of the day, what we are saying is that if we are officer of the state, in whatever that you do, you should have in mind that if you intentionally or out of the scope of your authority, do something that will occasion a form of judgment debt to the state will pursue you to get that money that is from you.
Right. So somebody's asking whether, for example, is there a schedule like this is how much we pay as judgment debt every month?
No, we don't have it. But I think if you take the budget every year, the budget that is presented to Parliament, you may have a section of the budget talking about the payment of judgment debts. But at our ministry, we do not have it.
And then somebody is also asking whether he wants to know whether the state has been successful in retrieving every money it considered illegal payment to Alfred Abwesi Woyomi.
I'll answer no. Efforts have been made. Some recoveries have been made, but we've not recovered everything from him.
Do you know how much money is still outstanding?
I cannot be specific, very sure, but what I can say is that some monies have been recovered from him. We also made an attempt to also do some execution when it comes to
of some of his property.
Yes. So we are still in the process, but he has not paid everything.
So those properties are in the hands of the state or they've been disposed of?
I don't know the update on it now. I need to check.
Okay. And then another person also says that is our properties in the United Kingdom safe because of this Trafigura matter?
Yes, that case too, we wrote to the finance ministry to enter into negotiations again with the judgment debtors. And my understanding
meaning
is that
we accept that we owe and we have to pay.
Yes. My understanding is that they are talking. But where they are now, I don't know the state of it. That's my understanding.
But our properties are safe?
Yes. But if you do not pay, at the end of the day, the judgment debtor, creditor may want to fine me. But I can give the assurance that the finance ministry is taking every step possible to ensure that negotiations are made. We agree on how much we are to pay and when and where, so that all those things will be taken care of.
So, Honorable, as we begin to wrap up, apart from the provision on compound interest and the conduct of officers assigned under this law with the responsibility to enter the state into contract with other parties, what are the other provisions that we should look out for?
Basically, these are the main provisions in this act. But moving forward, if there are other things that we need to do, let me commend Parliament. This bill went to them last year. It was passed last year. Then we have it signed this year. So, and when we went to Parliament, we didn't have any opposition. So it was bipartisan. We are a developing nation. New ideas may come up. When new ideas come up, maybe this act may be amended along the line. But this is a starting point. And
then the other matter is the criminal offences bill, which is also in Parliament.
Yes.
Is there any relationship between the two?
This one is about the civil side.
This one is about the civil side.
But the criminal side too, yes. We've also identified certain loopholes in the criminal side.
Like what example?
For example, it comes to the trial by jury. You have instances where you have 7 gentlemen and ladies sitting to try first degree like murder. In the event that one of them
is unavailable,
the case does not go on.
And for example, last year, you had a lot of strike by these people, and it affected the trial of cases, especially in the north.
Yes. We also have instances where the jury will sit in the case, they will finish maybe the day before judgment or summing up, one of them passes on. It means they have to start the case afresh, de novo. We want to cure that mystery by having alternate jurors.
Okay.
So you have 7, and then you may have other alternate jurors who also be sitting to observe the process. The moment one of them is absent or is not able to participate due to ill health or death, then the alternate juror will step in, sit in, and then the case will proceed. So that's one of the areas that we're looking at. Then you also look at instances where people go to court and delays in trials. How do we handle it? Because we've also made that suggestion in the bill that the day-to-day hearing of cases must rather be encouraged. There must be timelines when it comes to the trial of criminal matters. Then there are also provisions on interlocutory appeals. The proposal in this bill is that you can file interlocutory appeal only when you have closed, only when the state has closed its case.
Okay.
If, for example, a document is being tendered in the course of the trial and the accused person's counsel objects to it and is overruled, he has the right to go on appeal, but this bill is saying that, hold on, let's finish with the prosecution side
before we do that.
You do that. Yes. So there are other things
that you are looking into. Yes. Okay. All right. Honorable, thank you very much for coming. It's been a pleasure having you.
Thanks so much.
Thank you for the education on the amended contract law. And folks, so that's the Deputy Attorney General, Alfred Chianyabua, and taking us through the amendment to the contract law. And the responsibility is on stage actors. And you are now clear as to what you can do if you are to enter the state into any contract. The rationale behind this bill is to avoid the payment of judgment debt and net compound interest. Now, still